Today, we're going to break down the rule book for running a business in Papua New Guinea, the Companies Act. Look, whether you're already a director or you've just got that next big idea, getting these rules right is absolutely essential if you want to build something that not only works, but also protects you.
This is the big question, right? It's the one every single entrepreneur has to ask. You're putting it all on the line, but you don't want to risk losing your house if the whole thing goes sideways. Well, the answer is all in how you set up your business from day one. So let's get into the blueprint the Companies Act gives us to do exactly that.
All right, first up, we've got to talk about the most powerful concept in all of company law. And I'm serious, this is not just about filling out forms. It's about creating a brand new person in the eyes of the law.
Okay, so the main idea here, and it's a huge one, is that a company is its own legal person. It can buy property, it can sign contracts, it can sue somebody, and it can be sued all by itself. It's basically a legal shield that's totally separate from the people who own it and run it. This single concept, right there in Section 17 of the Act, is the bedrock of modern business.
And here is exactly why that matters so much. If you don't have a company structure, you and the business are the same thing. So if the business builds up a ton of debt, well, creditors can come looking for your personal car, your savings, your house. But with a company, there's a firewall. Your risk, your liability is limited to whatever you paid for your shares. Your personal stuff stays safe. That's the whole point.
So, the second superpower a company has is that it basically lives forever. Unlike a sole trader, the business isn't tied to its founders. I mean, a shareholder can sell out, a director can resign, but the company just keeps on going. All its contracts, its bank accounts, its property, all of it stays with the company. And that stability is absolutely critical for growing long-term and getting people to invest.
Now, let's get practical. You've created this separate legal person, right? Well, it needs an official name. And believe me, the rules here are super strict and for a really, really important reason.
So the number one rule you have to burn into your brain is this. Every company name has to end with limited or Ltd. This isn't just for show. It's a massive blinking sign to the whole world that they are dealing with a company that has limited liability. And you've got to use that full correct name on everything. I mean everything, from contracts to emails to letterheads.
So, why is the government so tough on this? Well, because getting it wrong can cost you a lot. If you fail to use the company name correctly, you could be looking at a fine of up to 5,000 kina. And that's for the company and for each director personally. Ouch.
And it actually gets way more serious than that. The fine is just the beginning. Let's say you sign a contract, but you forget to add the Ltd, or you spell the name wrong. Guess what? You could be held personally on the hook for that entire debt. That legal shield we were just talking about, it just vanished. One tiny mistake can have huge, huge consequences.
Okay, every company needs a rulebook, how it operates, how shares get transferred, how directors are chosen, how votes work. And you've got a big choice to make here. Are you going to write your own or just use the standard one that comes with the law? So here's how that choice really breaks down. You don't actually have to write your own rulebook, a constitution. The Companies Act gives you a default set of rules that works perfectly fine for most simple businesses. It's easy and it's free. But if you've got multiple investors or different kinds of shares or very specific rules you need to enforce, then a custom constitution is the way to go. It gives you that control and it becomes a legally binding contract for everyone involved.
Okay, so your company is alive, it's got a name, it's got a rule book, but how does it actually do business? How does this artificial person sign a legally binding contract?
This happens all the time. Founders often have to sign deals, like an office lease, before the company is even officially registered. The Act lays out a really clear four-step process for this. First, the founder, who they call a promoter, signs the deal. Then, once the company is officially incorporated, the new board of directors has to formally approve or ratify that contract. And it's only after that happens that the legal responsibility jumps from the founder over to the company.
But what happens if the company never gets formed? Or what if the new board just says, nope, we don't want that deal? Well, this is the risk the promoter takes. The law says the promoter makes an implied warranty, which is basically a promise that the company will be created and will take on that contract. If that doesn't happen, the promoter can get sued personally for any damages.
All right, let's move on to something that is a crucial, ongoing job, keeping records. And this isn't just boring admin work. This is about maintaining the company's official memory and being able to prove that it's being run the right way. The good news is the Act kind of simplifies a long list of requirements into three main buckets of records you have to keep. You've got your governance records, like the minutes from board meetings. Then you've got financial records, which track every single dollar in and out. And finally, shareholder records, which detail exactly who owns the company. And you can't just toss these in the bin at the end of the year. The law is very clear. You have to keep most key documents for at least 7 years. Why so long? Because these records are your proof. They're what an auditor is going to check, what a court will demand in a dispute, and what proves to the entire world that your company is financially solid.
And finally, let's talk about the annual cycle of reporting. Think of it like a yearly checkup. This is how a company stays accountable to its owners and to the public, and it's how you build the trust you need to operate. Right at the center of all this is a duty that you just can't get out of. Every single year, the board of directors has to prepare an annual report, and they're on the clock. It has to be done within 5 months of the company's financial year end, and it has to give a full, proper overview of how the company is doing. But this isn't a one-way street. For every duty the board has, the shareholders have a right to match it. As an owner of the company, you have the legal right to look at its core records. This creates a really powerful system of checks and balances. It makes sure the people running the company are being held accountable by the people who own it.
So, does every company have to go through a full and, let's be honest, expensive audit? Nope. The Act is pretty smart about this. It makes a clear split. If your company is small, we're talking under 5 million kina in assets, with fewer than 25 shareholders and 100 employees, you're probably an exempt company, and you don't need that audit. But the moment you cross any of those lines, you become a reporting company, and a formal audit is mandatory.
And that brings us to the final thought here. It's easy to look at all these rules, the naming stuff, the annual reports, and just see it as a bunch of boring compliance paperwork. But if you take a step back, you start to see that every single rule is actually a building block. Together, they create a structure that is stable, that's transparent, and that's legally protected. They turn a simple idea into a real, durable asset, one that can grow, attract investment, and even outlive the people who started it. So the question really is, are you just following the rules, or are you building something that's designed to last?